And thank you to all of you on the line for joining my partner Mike Lennon and I for this Mayor Brown Energy Practice webinar. Our program today will focus on force majeure and similar considerations for the oil and gas industry in the aftermath of Hurricanes Harvey and Irma. I'll cover a couple of administrative matters first, and then we'll get started. For CLE credit for the lawyers on the line, during today's presentation, you will be provided with an alphanumeric code. If you're applying for CLE credit, you'll need to record this code on the virtual sign-in sheet that you received by email with the connection details. You'll find directions for returning that virtual sign-in sheet on that sheet. We will read the code in the middle of the presentation and then again at the end. We plan to allow about 10 minutes at the end of the program for questions. To submit a question electronically, please use the Q&A panel in the WebEx. And if we aren't able to get to your question during this webinar, we will make every attempt to follow up with you after the webinar. And please also feel free to reach out to us individually afterwards if you prefer to ask questions that way. This webinar is being recorded, as we normally do with these programs. In a day or so, we'll be sending you an email with a link, which you can use to listen to the webinar again or to share it with your colleagues. And the recording will also be posted to our website. By way of introduction, Mike Lennon and I are both litigation partners in Mayor Brown's Houston office. Energy-centered commercial disputes are a primary focus of each of our practices, including in federal and state court litigation, arbitration, and pre-litigation negotiations. And with that brief introduction, let's get started with today's program.
Thank you, everyone. So we have an overview of what we're going to cover today, the 5 basic elements of the presentation. We will set the stage with some information about past hurricanes and the pathway of Harvey and Irma. We'll have a primer on force majeure, just to outline the basic framework in which force majeure operates. We will have some case studies from the aftermath of Hurricanes Katrina, Rita, and Ike to give you some sense about how these issues have been decided in similar circumstances, and then the takeaways for either side of the equation. Setting the stage, the experiences of Hurricane Katrina, Rita, and Ike are emblematic of what is likely to be the fallout from Harvey. Katrina and Rita shut in more than 8 BCF, billion cubic feet of gas production, and 1.5 million barrels of daily oil production. Virtually shut down entirely the rubber industry between Houston and New Orleans for nearly a month, among other impacts. Ike, which followed on the heels of Gustav in 2008, had a similar effect on oil and gas production, caused massive disruption to the chemical industry, not only from shutting down for the storm, but also the disruption of suppliers that prevented restart. And, unsurprisingly, substantial force majeure litigation followed. If you're interested, there's a link here to a government website that has some interesting information in a report on the consequences of the series of hurricanes, including effects on the energy industry and more broadly. Here we have a map that shows the pathways of both Hurricane Harvey and Hurricane Irma. On the far left, the bright green line was the path, ultimately, of Hurricane Harvey when it was still hurricane status. And then you see it stalls out there to the east of San Antonio, basically right over Victoria, Texas, and then moved on out into the Gulf and then through Louisiana as a tropical storm. On the far right, the bright green line is Irma. Now, the thing to note about this map, we've overlaid all of the oil and gas production and pipelines. So you can see that there was a significant risk to critical oil and gas operations in the western Gulf of Mexico at the initial stage, and then moving into the more central portion of the Gulf of Mexico as Harvey moved out as a tropical storm. Now, don't be deceived by the pathway and the skinny line. Harvey was massive, and you will recall, those of you who followed it because you lived in the potential pathway, it wasn't exactly clear what the initial pathway was going to be for Harvey, and some projections had it coming onshore much closer to Houston rather than Port Aransas, Corpus Christi. As a result, it can be expected that significant shut-ins occurred in the central Gulf of Mexico to protect production facilities and production from the consequences, wind, rain, etc., wave action from Harvey, not knowing where the path was going to go. Now, in addition to what you see here in oil and gas operations, all along the area, basically from Corpus Christi over to Lake Charles, is a huge segment of the chemical and petrochemical industry in the United States. And all of those facilities, by most news accounts, were shut down to ride out the storm. And then several took on flooding in the aftermath of the storm and were not able to restart for a significant period of time. Some still have not restarted, at least one, according to today's Houston Chronicle. So as I said, Harvey, you can imagine, wreaked havoc on the energy industry from Corpus Christi to Lake Charles. The full scope of the damage is not yet completely understood. There are still assessments underway, but there were significant interrelated weather events involved in Harvey. There were numerous tornadoes, then of course the flooding that came along with all of the rain as Harvey just sat on the Gulf Coast. Some estimates of the total damage from Harvey are upwards of $180 billion, and like Katrina, Rita, and Ike, substantial litigation is expected to follow. So what does that litigation look like? This is by no means an exhaustive list, but because of the shut-ins and shutdowns and damages to facilities and whatnot, there is likely to be a significant force majeure litigation event in the coming years. Some of those cases from Ike that we'll talk about later didn't get resolved for 3 or 4 or 5 years after Ike, so this is going to be a protracted litigation. A couple of obvious kinds of arguments that are going to arise in that litigation. That is failure to supply, whether it's oil and gas being shut in or facilities being shut down and unable to deliver, versus a force majeure declaration in response to the storm. And then you have the knock-on effect from that, and that is force majeure due to suppliers' failure to supply. So and there are multiple iterations that follow from that. And then, of course, you're going to have, in response to the force majeure declaration, assertions that the party asserting force majeure was negligent in their preparations for the storm or their efforts to get out of the storm. With that, I'll turn it over to my partner, Jessica Crutcher.
Good morning again, everyone. I'm going to speak a little bit about the legal issues surrounding force majeure in combination with some of the practicalities that arise out of those legal issues. First of all, force majeure type issues arise in both contract claims and tort claims. Most jurisdictions recognize a force majeure or act of God, as it's often called, type of defense in tort claims. These claims usually arise when the plaintiff has suffered some sort of physical injury, usually to property, as a result of a severe weather event. For instance, a floating rig or some part of that rig can come unmoored in a hurricane and cause damage while floating loose in the Gulf of Mexico. I'll talk more about these type of situations and how the courts tend to handle them shortly. But for now, I'm going to talk about force majeure in the contractual context because that's where we tend to see the most sweeping issues. Most of the time, for the people listening on the phone today, the type of contract you'll be dealing with will contain an enforceable force majeure clause. And of course, when assessing whether you're dealing with a force majeure situation, that force majeure clause in your contract is going to be the first thing you need to look at. Every force majeure clause is different, especially when you're dealing with heavily negotiated contracts. However, some of the key things you should look for when addressing your situation is what the clause says about, first, whether the event must have been unforeseeable and whether that term is defined. Second, to what extent events must be entirely beyond a party's control. Third, whether the clause requires impossibility of performance versus merely reasonable efforts or some other standard, and whether those terms are defined. Fourth, mitigation requirements, which may be worded in reasonable efforts language or in some more precise way. And fifth, any notice requirements on the party claiming force majeure. I note that unless the contract is particularly complex, your clause is probably not going to include all of these elements at this level of detail, but it does sometimes happen, so you should look. And finally, although it's unlikely to be stated in the force majeure clause, causation is, of course, a key element. You can't claim force majeure if the event didn't actually cause the inability to perform. One example here would be pre-existing supply problems. A party claiming force majeure should expect the other party to be asking questions about any pre-existing problems, and the party on the receiving end should be asking those questions if they don't already know the answer. Depending on the contract, the types of events included as force majeure events may be very general, i.e. acts of God, war, governmental orders, and such. Or they may be much more specific and include subparts such as inability to obtain fuel, inability to obtain power, inability to obtain transportation, materials, or other issues that, especially in heavily negotiated contracts, the parties feel are most likely to be a force majeure issue for them. Here, we're talking about hurricanes. The obvious force majeure issue is a so-called act of God, Hurricane Harvey, Hurricane Irma, the flooding that came from those hurricanes. However, there could be other force majeure issues that arise in connection with the hurricane, such as government orders. An easy example here would be government-ordered shut-ins, shutdowns, evacuations, or road closures, which also can have an effect on many of the contracts that you all are thinking about right now. Even though there are always exceptions, courts across jurisdictions tend to take fairly consistent approaches to what the law is in force majeure type situations. If there's a contract, it should control, unless some part of it is unconscionable or otherwise unenforceable. If there isn't a contract, common law, or in the case of Louisiana, the civil code, takes over. Today I'm going to talk briefly about how Texas, Louisiana, the Fifth Circuit, and certain international tribunals tend to handle these situations. In Texas, impossibility is recognized as a common law defense to contract performance, where there isn't a controlling force majeure clause in the contract. In practice, the impossibility defense is often called a force majeure defense, frustration of purpose, or commercial impracticability, among other things. But whatever it gets called, the standard is the same. Impossibility, as opposed to mere impracticability or inconvenience, will usually be required, if there isn't a contract, of course. For example, a number of courts have addressed the issue of financial impossibility. While there's a spectrum on which these cases exist, it is clear that in the absence of a contract provision saying otherwise, merely suffering the inconvenience of lowered profit margins does not reach the level required to mount an impossibility defense to performance. On the other hand, a court would seem unlikely, from all of the cases that we've read, to require a company to take such extreme measures to perform that it risks bankruptcy, for example. Now, these are two extremes in the same situation, right? and most cases are going to fall somewhere in between. And in those situations, the other facts, including foreseeability and what remedial measures the party claiming force majeure took to prevent or mitigate the situation, are likely to color the court's view. In Louisiana, when you don't have a contract, the Civil Code provides for a force majeure type defense where no clause governs. The Louisiana Code contemplates what is roughly a three-part test. First, that the event was unforeseeable at the time the contract was made. Second, that the event rendered performance impossible in whole or in part. And third, that the event was fortuitous, the implication here being that it was beyond the party's control. Impossibility by itself is a high standard. While not all Louisiana state courts have taken as strict of an interpretation, some courts have emphasized that under this test, impossibility alone is not enough for a force majeure finding. In other words, you have to have the other two requirements met as well. An extreme example of this distinction would, in theory, be a situation where two parties entered into a contract for short-term services at the exact same time that a major hurricane was bearing down on their city. And then one party claims that force majeure based on that same hurricane. Not surprisingly, we haven't seen a reported case with those circumstances, and in that situation, it's pretty hard to imagine. But you can imagine that if that were to happen, the party claiming force majeure would probably be hard-pressed to say that the hurricane was not foreseeable. And we will note that we see some questions coming through right now, so thank you all for your questions, and we will circle back around at the end. So, a more nuanced approach to this extreme situation that we hypothesized about is presented in Farnsworth v. Sewerage and Water Board of New Orleans, which is a Louisiana Supreme Court case from 1932. That case addressed a force majeure claim in a construction contract where the contractor claimed a force majeure event preventing completion by the date in the contract because of several months of heavy rain followed by a few days of extensive flooding. Under the Civil Code test, the Louisiana court drew a distinction between the rain, which it decided that the contractor should have accounted for and built into the promised completion date, because it rains a lot in Louisiana, and the few days of flooding, which, based in part on pictures of canoes floating down streets in place of where vehicles or foot traffic would normally be, the court found was fortuitous and unforeseeable. So there was an in part force majeure defense to performance, but not entire in that situation. Contract disputes like the ones we're talking about today usually reach the Fifth Circuit either under diversity jurisdiction or federal maritime jurisdiction. The Fifth Circuit covers Texas, Louisiana, and Mississippi. And the Fifth Circuit will apply either the substantive law of the appropriate state, which may be based on contract, or it may be based on other choice of law principles, or if federal maritime law applies, the Fifth Circuit will apply federal maritime law. Federal maritime law, which, among other situations, may apply in certain cases involving floating rigs and drill ships in navigable waters, also recognizes an act of God defense. And with that, I am now going to turn the microphone over to Mike to talk about force majeure in the international context, including, if he has time, a little bit of his experience with the doctrine in international arbitration proceedings.
So force majeure is recognized internationally. And internationally, most legal systems are civil systems. We've got some examples here of force majeure provisions that I have dealt with in cases and arbitrations and litigations in the past. They'll be in Civil Code 360, the UAE Civil Transaction Law, Section 472, Indonesia, and the People's Republic of China, Contract Law, Article 117. In common law countries around the world, former British Commonwealth countries, force majeure is dealt with under the label frustration, which again, like the civil code systems, revolves around the principle of impossibility. And here we see the common requirements for either the doctrine of frustration or the civil code systems that I've mentioned and others. First, generally the event has to be beyond the party's control. Second, unforeseeable or unavoidable. And third, the event must render performance impossible in whole or in part. Now, a couple of things to note about civil law jurisdictions. First, you can contract out of the code-based force majeure principles and include a force majeure clause in your contract, and that will be recognized because force majeure is not doctrinally a matter of public order in any these countries around the world. A couple of examples that I can give you that I've dealt with or had to assess. In the UAE, we had a number of matters. They were in the construction field, in which force majeure was asserted by owners of buildings being built that were not completed on time in cases brought by the tenants that had signed up. Largely, these were residential properties that had tenants that had pre-bought into the building. The force majeure situation in those cases was twofold. One was the financial crisis. Everyone recalls that well. It had a significant impact on construction in the UAE and Dubai in particular, but also elsewhere in the Middle East. Generally speaking, that defense was not successful. As Jessica mentioned earlier, it's a high burden to establish a financial force majeure. The other aspect of those cases was unavailability of materials, which was a result of A, the significant explosion in construction in the Middle East, making it difficult to get materials or workers, and then B, on the heels of that explosion, the financial crisis hit, and so the suppliers of materials were not in a position to produce more materials at the rate required to keep going with construction. There was mixed success with that defense, but generally speaking, also difficult to prove. Another example that I would share with you comes from Libya in the Reagan era. You will recall, well, maybe you'll recall, President Reagan issued sanctions against Libya preventing anyone with a U.S. passport from traveling to Libya. But they were not financial sanctions associated with that like there were in 2010 when the Libyan civil war broke out. The case that I have seen that dealt with that is Sun Oil versus the National Oil Company of Libya. And the tribunal in that case, it was an ICC arbitration. The tribunal in that case rejected the force majeure defense, saying Sun Oil had not established that it was impossible to carry out the operations in Libya with non-U.S. personnel, and that the sanctions were not otherwise broad enough to prevent any, workarounds, so to speak, or mitigation measures, like Jessica mentioned earlier. Rather, the sanctions were quite narrow, and therefore the defense was unsuccessful. So with that, I think we've got a few case studies for you to consider, and Jessica will present those. Mouse seems to be...
We're having a mouse issue. Electronic, not four-legged.
There we go.
Excellent. All right, everyone. I'm going to talk briefly about some general takeaways from the contract and tort force majeure type litigation that arose out of Hurricanes Katrina, Rita, and Ike. And after that, I'll hand the microphone back to Mike, and he's going to talk about what all of this means, practically speaking, for companies that are trying to decide how to handle their own force majeure issues right now. On the contract side, the first lesson is that if there is a contract, the language of that contract is most likely going to control heavily. For example, in the Ergon case, in the first bullet point, the Fifth Circuit, applying Texas law, addressed the failure to provide gas per a supply contract after Katrina and Rita caused major infrastructure damage. The Fifth Circuit, instead of applying a stricter impossibility standard under Texas law, focused on the language of the force majeure clause in the contract, which was a little more forgiving, along with parole evidence, because the court found that the language of the contract was ambiguous. The Fifth Circuit ultimately affirmed the district court's ruling, which was that performance was excused by the force majeure clause because under the reasonableness standard that was specified in the force majeure clause, the court found that there was no duty to secure replacement gas from some other source. Now, Virginia Power, the case in the second bullet point, is a Texas state case that also deals with the failure to deliver natural gas after Katrina and Rita, and it underscores the same point. Here, the 14th Court of Appeals in Houston upheld the lower trial court's grant of summary judgment for the producer, finding ultimately that the reasonable efforts provision in the force majeure clause in the contract did not require the producer to find a way to make delivery at some alternate place when the specific delivery location was specified in the contract. Now, on the other hand, courts may take a closer look at a force majeure defense if there's a real suggestion that the party claiming force majeure is being less than honest about the reason for non-performance. The Payne case in the fourth bullet point out of Louisiana is a good example of that sort of situation. Now here, the seller of a house claimed he couldn't perform the contract of sale, which required, this was before Katrina, required that he make some repairs and that they close within 60 days. Well, then Katrina happened. There was some more damage to the house. He said he couldn't get supplies. And there was no force majeure clause in the contract, so the Louisiana code governed. Now, the court focused heavily on the fact that the buyers were willing to extend the closing date to allow additional time for repairs, and the seller was the one who refused to extend the closing date. Now, the court noted that the seller appeared to have been less than credible in his statements about supposedly delayed materials, which undoubtedly played a factor in the court's opinion. And the subtext, although the court didn't specifically state this in the appellate court opinion, appeared to be that the seller wanted to walk away from the deal for some sort of financial gain. So those are the motives that courts are going to be looking at that, you know, may underscore what on its face appears to be a more purely legal decision. And, you know, the Payne case raises a very important point, which is that parties should consider reasonable alternatives when possible. They need to communicate with other party to the contract. And, of course, most importantly, don't be dishonest. We included the Dollar Thrift case in here simply because it's an interesting case study. It involves both contractual and tort elements. But ultimately here, the plaintiff was upset because the individual who was storing Dollar's cars in New Orleans pre-Katrina, well, the cars all ended up getting flooded. They were all, you know, a complete and total loss. And Dollar said essentially, well, you know, you knew the hurricane was coming. You should have taken some sort of effort to get the cars out of the way. And, while that may seem reasonable on its face, what the defendant said, and the court, agreed with him as a matter of law, was, look, at the point that we got notification this hurricane was coming, we were under mandatory evacuation orders. The roads were clogged. People had been ordered to leave town. I didn't have employees with which to get the cars out. I didn't have any place to take them. I didn't have any place to store them. And the roads were clogged with cars, so I couldn't get them anywhere anyway. And that rationale, which included, a very obvious rationale of why the decision was made to not move the cars in the first place, was very important to the court's decision. And, obviously this isn't an oil and gas case, but the same sort of rationale applies. Now, on the tort side of force majeure, given the sheer amount of infrastructure damage that we already know about, tort cases in the oil and gas arena are a certainty post-Hurricane Harvey. As we talked about briefly earlier, in the absence of other controlling law or statute, most jurisdictions recognize an act of God or similar force majeure type defense in tort cases arising out of severe weather events. The lesson we see from these cases is that in catastrophic events with lack of meaningful foreseeability, a party has a reasonable likelihood of success if it made reasonable efforts to prevent property damage to others. For instance here, the Simmons and French Quarter cases, the second and third bullet points on the slide, which involve a 40-foot sailboat and a tree, respectively, both resulted in the Louisiana Appellate Court upholding a grant of summary judgment in the defendant's favor based upon this approximate set of circumstances I just described. And those were both Hurricane Katrina cases. On the other hand, in the Comeau case, which is the first bullet point, which is an oil and gas case, the Federal District Court for the Western District of Louisiana denied the defendant's motion for summary judgment on a force majeure basis. And in this case, a number of the defendant's 1,200 to 1,500 pound oil field mats became dislodged and floated off during the storm surge that was associated with Hurricane Ike and damaged neighboring property. The key issue there in the court's decision appeared to be that, at least at the stage in the proceedings where this opinion was written, the court suggested that the defendant had taken no mitigating efforts at all to ensure that their equipment stayed secure during the storm. And they did not appear to have proffered any sort of good explanation for why they didn't take any mitigating efforts at all. And there appeared to be quite a bit of evidence that, other folks in the same area took mitigating efforts that this particular defendant did not. So ultimately, the court decided that this created a fact issue as to whether the defendant's lack of action was reasonable, and ultimately how bad of a weather situation the defendant should reasonably have foreseen. So I suppose the lesson we take from all of these cases is that while there are always going to be clear decisions on the far ends of the force majeure issue, there is a lot of gray area in the middle that is going to depend on the individual facts and circumstances and what the parties did or did not do. And on that note, I'm going to pass the microphone back to Mike to talk about the type of issues and actions companies ought to be thinking about right now.
Well, first and foremost, if you're planning to declare force majeure, you better give notice that you're claiming force majeure. And that timing is probably about now. Courts will give some latitude for a party in circumstances of a major weather event to take time to assess the damage that has been done, to try to get a reasonably comprehensive understanding of both what the consequences were and what steps need to be taken to remediate. At that point, they will expect a party claiming force majeure to be in a sufficient position to be able to give notice. Notice is implicit, I would say, in statutory or common law doctrines, and explicit, almost always, in contract provisions. But regardless, it is in your best interest to communicate with your counterparty and declare the force majeure event. Now that begs the obvious question: what do I say in the notice or the response and so forth? And you're having to balance not necessarily having completely your assessment versus not wanting to limit, should there be future litigation, what it is that you claim was the force majeure event or the consequences of it. Now, it's kind of obvious that Hurricane Harvey is the force majeure event in the context in which we are having this conversation. But not every consequence of Harvey will necessarily be a force majeure event. So the notice should establish the connection between the hurricane and the force majeure event in order to be a successful notice. My advice to you would be to be reasonably complete and comprehensive, not necessarily detailed in your notice, and to include appropriate caveats regarding the status of the investigation into the event and the consequences of the event, and to reserve the right to update the force majeure notice in order to add any additional consequences that are discovered in later investigation and so forth. The response. Most contractual provisions don't require a response. Some do if the force majeure declaration is rejected. But in any event, our advice would be to respond to protect your position. The primary reason being, if there is subsequent litigation, the notice of force majeure is going to be Exhibit 1 in the litigation, and there will be no answer to it, leaving the implication for the decision maker that the force majeure declaration was accepted at the time, and now the rejection of it in the litigation is just after the fact, trying to get a better outcome. The response may or may not contain a detailed rejection or argumentation on what the consequences were, because the party may or may not be in a position to do that. But it should include reservations of rights for sure. It may want to say we're not in a position to agree or not agree at this stage until we have further communication. It may request more information. It should, if you feel like you're not in a position to really assess the force majeure claim. And of course, reserving your right to reject or accept or add additional reasons for rejecting in the future. The third little dash there is an amended or updated notice. This is recommended if you have a significant change in what it is you're claiming was either the cause or the damage resulting from the force majeure event. It may be that it's some latent issue that's not discovered until, for example, you're returning a petrochemical facility to production and you discover some machinery that you didn't take apart and examine is having a problem, and you can connect that to flooding damage, for example. So you'll need to be mindful of updating the force majeure declaration as events unfold. In terms of style, the last bullet point answers the question. Assume the letters will be exhibits in a litigation and draft accordingly. So not screechy in tone, just factual, matter-of-fact declaration. Probably ought to leave the adverbs ending in ly out of the letter, and the same in response, so that you're giving the appearance of a rational, thoughtful, contractual counterparty when you have this exchange of correspondence. And again, the reservation of rights and the caveats I mentioned before are musts in the situation. So what are the takeaways for a party claiming force majeure? You've now heard some of the case studies, and Jessica has already said the words of the force majeure clause really matter, and that really, really is true. The broader or force majeure clauses are going to be easier to make a declaration under. If it's a narrower clause, it's going to be harder, and your notice of force majeure should hew to the words of your force majeure clause in terms of what the event was, what your consequences are, the reasonable steps you're taking to overcome the force majeure, and so forth. Just be very, very mindful of the clause as you're drafting your force majeure notice. Clearly, prompt preventative action is a best practice. In the oil and gas industry, this, almost goes without saying. Production facilities are shut in, and people evacuated from rigs and so forth as a matter of course. But be open to and mindful of other preventative actions that you may want to take in terms of possibilities for alternative performance. For example, in the next bullet point, do you want to enter a spot contract for gas or a swap contract for gas in order to be able to supply somebody even though your facilities are shut in, if it's economically feasible to do that? But we clearly see in the cases that if you don't take any reasonable steps in the face of a natural disaster to minimize the consequences of the disaster for your business, then you're less likely to get a sympathetic ear in the litigation that follows. The next bullet point, consider the alternatives. I gave you an example of that, or can you partially perform? The fourth point is really the crucial one in terms of the commercial relationship, and that is to communicate promptly with your counterparties, of course, always in compliance with the notice requirements, whether that probably requires a writing, but it is also probably commercially helpful to pick up the phone and call the counterparty and say, hey, we're having to shut down because of the hurricane, this is coming. It's not going to prejudice your subsequent written notice, but a heads up is always usually well appreciated in my experience. Compile the evidence necessary to support the claim, and at all times keep your eye on causation. There was an interesting case I saw when we were preparing for this in Louisiana where it was a contract for the supply of animal pelts, and the case came up because the party that was required to supply animal pelts didn't supply them after Hurricane Katrina. And the interesting twist in the case is that one of the witnesses for the party claiming force majeure testified shockingly candidly, no. We stopped supplying pelts to our buyer because we were unhappy with the grades they were giving our pelts. They were grading them too low and not paying us enough for them. Well, you can imagine force majeure failed in that case. So keep your eye on causation and make sure that you can connect the dots between the event, whether it's wind or rain or flooding, and what it is you're claiming was the consequence of it. And remember your other contractual protections. Don't put all your eggs in the force majeure basket. You often have consequential damage limitations in your provisions. You have limitations of liability at the value of the contract, for example, and other protections that may be there for you. So use force majeure, but don't leave out any other defenses. As you've seen, force majeure is by no means a slam dunk defense. So now you're on the other side. You've received the force majeure notice. Guess what? The words of the force majeure clause really matter to you too. And the key takeaway, I think, from the cases, if you're responding to a force majeure, is to consider alternative causes very seriously. Do your own investigation. Go back through the correspondence with the counterparty and see if there were already issues with their performance entirely unrelated to the weather event. Again, communication is key. There's no reason in a commercial, professional business setting for there not to be ongoing communications. Of course, if you get to the point where you have hired outside counsel, this recommendation, of course, has to be taken in due deference to the legal advice you get. But in our experience, communications minimize the risk of litigation and maintaining the commercial relationship. When you're on the flip side, of course, compile your own evidence, keep your eye on causation, and remember your other contractual protections. It's different sides of the same coin, so to speak.
And we're now going to move on and address some of the questions that we've had come in.
So one of the questions is, can you download the presentation afterwards? Yes, you will get an email with a link in order to be able to do that. So we're trying to scroll through the box to see the questions. So one question here, I think that is the 30,000 foot or the $64,000 question is it indisputable that Harvey is a force majeure event? Well,
no.
I would say yes and no, but no, it's not automatic. Because it depends on the connection between what it is that you are claiming was the consequence of Harvey and whether you can prove it and connect it to Harvey, whether it be wind, flooding, or so on. Jessica?
Right. I mean, and, the other issues that we talked about and, the various other considerations that courts may look at, along with anything else that may be in your contract, right? I mean, I think indisputably you're looking at a hurricane as a force majeure event if you're just looking at that one single issue by itself, right? But the fact that there's a hurricane isn't the only consideration here. So if you're required under your contract to try to find some other way to perform or deliver, and there is some other way to perform or deliver, then that may be the answer to your question, for instance. Or if you could have taken, reasonable steps to mitigate the issues ahead of time and, failed to do so, and the court finds that failure to mitigate was not reasonable, then in that situation you may not have a force majeure event.
So maybe stated differently, Jessica, Is a hurricane an indisputable act of God?
Yes.
Yes. Does it mean your force majeure defense will be successful? No.
Right. So another question that someone has sent through here is, how critical is the notice provision in a force majeure clause? What if the notice provision isn't included? Mike, would you like to talk a little bit more about that?
Sure. So that's a tricky one. It is going to depend on the law of the jurisdiction that applies, because some jurisdictions will consider force majeure notice to be a condition precedent or condition of the defense, and failure to give notice is going to be fatal to the defense. Other jurisdictions take a more relaxed approach to that, and that is assuming you give notice at some point, as long as there has not been prejudice to the party against whom the force majeure defense is asserted, then strict compliance with the notice provision will not bar the defense. And I will tell you that you're going to get a more sympathetic ear on that if you're in an arbitration than if you're in a litigation.
Well, our next question we have is, what if there's no consequential damage disclaimer in the contract? If there's a legitimate force majeure event, will it excuse performance and protect against consequential damage claims allegedly resulting therefrom? Well, I think the answer to that question is that if you have a legitimate force majeure defense, then it should protect you against damage claims.
Yeah. It's an excuse to performance, and therefore any claim for breach that is excused by the force majeure defense, all damages associated with that will be barred by the successful assertion of a force majeure defense.
I mean, the constant caveat there is always look at your contract and see if there's something weird or unusual. But you know, generally speaking, a force majeure event, if proven, is a complete excuse to perform, generally speaking. Mike, you want to pick the next question?
Okay. So the next question we have is, what are your views on notifying the counterparty that the force majeure event has been resolved, even if such notice is not required under the contract? I think that's advisable if you're comfortable that you have in fact resolved your force majeure event and are resuming performance under the contract. It's difficult for me to see a downside to letting your counterparty know you're ready to perform.
It looks like we have time for one or two final questions here. The next question that we have is, if it is determined that the party claiming force majeure did not have the right to, is that party possibly liable to the other for breach of contract for the failure to perform the obligation which was the subject of the claim of force majeure? The answer there is a clear yes. Mike, do you have anything to add to that?
What Jessica said. Yeah, I mean, that's the idea, right? You only assert the force majeure if you're unable to perform and would be subject to a claim for breach. And so if you fail on your force majeure clause, you're liable for breach of contract.
We have one final question that just came in. So we'll address that real quick, and then we'll give you the code one more time. The question is, if you let your counterparty know that you're able to presume performance, do you need to send a letter, or will verbal notice suffice? we would typically recommend sending written notice. There's a lot of litigation out there that went on for a lot longer than it needed to because of he said, she said situations about what was or was not said over the telephone.
Yeah, I agree with Jessica. And you want to establish, when you notified your counterparty that you were prepared to resume performance, because if they undertake some, say, cover purchase of gas and you've told them, no, we're going to be able to start supplying gas again on October the 1st, and they enter into a short-term agreement that gets them gas through the end of October, being able to document when you told them and then show that they entered into the contract after that date means that you're not going to, you'll have a pretty clear defense to being on the hook for the purchases of gas beyond October the 1st.
I think we're about out of time. There is one question that we just saw partially come through, but it hasn't come all the way up on our screen yet. It looked like the question was essentially, can you terminate a contract for force majeure reasons if the force majeure clause doesn't give you a right to do so? And the answer to that is really it depends. It will depend on the situation, it will depend on controlling law, and it will depend on the other terms of the contract. So that's the type of issue that you would definitely want to have a lawyer look at and give you some real advice on.
Right. For example, some of the civil codes that I mentioned around the world have specific provisions that say you can terminate based on a force majeure event. But I think the broader answer is, as Jessica said, you need to take specific legal advice based on the particular law governing your contract or your situation if there isn't a written contract.
Thank you all for joining us today. On behalf of Mayor Brown and me and Mike, thank you for your time. I hope you found it useful. Thank you all very much for your time today. Feel free to follow up with Mike and I if you have additional questions, and I'm going to turn the call over to the operator for closing formalities.
Before we do that, why don't we give them our email addresses so they can reach out to us?
Excellent. And if you don't have a pen to write them down, they're also on the front page of the slides. Mine is J. Crutcher. Are they not?
No.
Oh, okay.
But our phone numbers are.
Mine is J. Crutcher, J-C-R-U-T-C-H-E-R, @mayorbrown.com, and Mike's is M. Lennon, M-L-E-N-N-O-N, @mayorbrown.com.
Perfect.
Everybody have a great day.